morning, distinguished judges of the Ninth Circuit Court of Appeals. I'm Don Bennion. I represent Edward Stoltz in this matter. Thank you at this time for taking the time to hear this important case. I'd like to reserve 2 minutes for rebuttal at the close of following opposing counsel's statement.
Okay, please watch your back.
Thank you. I'd like to start out with a couple of points in introduction. First, the court order, the district court order, the undisputed facts are very one-sided, and I want to point to page 5 of the court order, that's SER 5, and read it under the disputed facts section, where I think there says plaintiff testified in his deposition that he had several combative interactions with the Safeco adjuster on the phone. He testified that when he contacted the adjuster's supervisor, there was an attempt to try to humiliate or intimidate him, that she was not sympathetic to his complaint. Plaintiff's own testimony is the only evidence of these interactions, and defendants dispute them. Defendants do not dispute these interactions. There's no affidavits from either of the adjusters and representatives from Safeco that talk about any of their telephone conversations. The affidavits from the Safeco.
Oh, what? How was that point significant?
Because it goes to the manner in which the good faith that Safeco is required when they issue a policy of insurance to my client. They have a duty of good faith. They're in a superior bargaining position. They're in a position of holding the money.
Still kind of waiting to try to figure out how the fact that maybe the person on the other end of the phone call wasn't as sympathetic as possible provides a cause of action. Well, either the money needed to be paid or it didn't need to be paid. That's really what we're talking about, insurance coverage.
Well, that's correct. But
okay, so how does this have anything to do with whether or not money should have been paid by the insurance company and was not?
Because when they go to the point of making fun of my client's clothes, saying that, oh, are you wearing Hager pants? That goes in direct violation of the Supreme contract.
So this whole cause of action is because your client has hurt feelings about his attire?
That's not the entire.
Is that a cause of action?
That is a cause of action.
Really?
I believe it is.
Any authority for the proposition if the insurance company honored its obligations under the contract could still have violated an obligation of good faith and fair dealing because the call representative wasn't as sympathetic as perhaps should have been on the phone?
Well, it's more than being unsympathetic.
I don't understand that as a cause of action. I just don't see where that comes from, and so I don't see how this factual element you're pointing to makes any difference.
And I appreciate the question, Your Honor. But with respect to the fact that this just wasn't one telephone conversation, there was multiple telephone conversations. There were letters written. There was information provided. And
but counsel, if we were to reach the merits here, I mean, it seems pretty clear that the insurance company kept asking your client for a detailed appraisal, detailed evaluation of what he lost, and your client kept failing to give it to them. So how could the insurance company, if we reach the merits, violate any contractual duty when your client continually failed to give them what appears to me to be the reasonable information they requested?
Thank you for that question, Your Honor. It's interesting to note that in Safeco's motion for summary judgment, they don't have the burden at trial, so they have the burden of production and then the burden of persuasion, as you know, in their motion for summary judgment. But they produced my client's responses to requests for production documents as part of their motion for summary judgment, Exhibit 19. And in that production from my client, he produced, as required under the insurance policy, a notice of the police incident report, but not only a notice of the police incident report, documents which show that he had money taken out of his account by the assailants.
But things that were produced in discovery, I mean, is really neither here nor there with regard to what he gave the insurance company to support his claim before he sued.
What he did give them, and I'm sure you're aware, was a 6-page letter.
I've read it.
And according to your brief, provided them with a detailed itemization of his personal property losses with approximate values for stolen belongings. Is that what you're referring to?
I'm referring to the 6-page inventory that was sent through his counsel.
And is that the thing with approximate values?
That did not have the approximate values.
Because when I looked at the ER reference, it gets me to that 6-page inventory. So the statement in the brief that it came with approximate values doesn't appear to be correct. Is there something that did provide approximate values for the items on the list?
There, and I apologize for not making that reference more clearly, Your Honor, but there is a reference in the responses to requests for production that do show specific values with respect to.
And those aren't the pages cited in your brief, so I'm going to have to go out and find it someplace. Do you have a reference that you can give us?
I do, Your Honor. I have multiple references. This is 19 to St. Post motion for summary judgment, CR 421 and 422. And that talks about, that only talks about the nature of the email between the adjusters, but with regard
Could I get to the jurisdictional issue for a moment? We had asked you about that. Your motion for summary judgment is seeking $300,000 in punitive damages, but do you allege anything that would support that sort of award under Nevada law?
Well, we do with respect to the fact that it's a breach of, the tortious breach of.
Jurisdictional issue for a moment, we had asked you about that. Your motion for summary judgment is seeking $300,000 in punitive damages, but do you allege anything that would support that sort of award under Nevada law?
Well, we do with respect to the fact that the tortious breach of complaint for implied covenant of good faith and fair dealing is with respect to the efforts undertaken by my client. The fact that he had to retain an attorney while this investigation was going on, and a letter was sent from his attorney on April 17th.
So in Nevada, it's oppression, fraud, that the insurer acted with oppression, fraud, or malice and subjected the plaintiff to cruel and unjust hardship. And oppression is a conscious disregard for the rights of others. So what in your complaint is it the delays and insults, the intimidations or bullying that you say in your summary judgment, or what supports that charge?
Those elements, as well as the fact that my client had to retain counsel to deal with Safeco. He felt, and he testified in his deposition, that they had become very adversarial in their approach to him. And so that's why he retained counsel. And on April 7, 2010, counsel sent him a letter, or sent Safeco a letter to the effect of the inventory that was lost. But it largely goes to the
That law provide for recovery of attorney's fees in that context.
It does with respect to breaching the tortious breach of the implied covenant of good faith and fair dealing.
So that becomes part of the damage.
That's correct. And to answer your question more fully with respect to citations, on February 18, 2010, this is SCR 445 and SCR 449, in the record, ACH debit electronic transfers to in the amount of $10,000, as well as a $1,000 check was written on my client's account that had been stolen, checks that had been stolen from his car that were covered under the insurance policy.
And was that information provided to the insurance company before your client sued?
It was provided to the police. It's unclear.
My question though, was it provided to the insurance company before your client sued?
It's unclear from the record whether it was provided. My client simply turned it over to his attorney. His attorney did not send that.
But there's nothing in the record which would
South Union or drive here at the asking officer to his green lane, Mueller Spring Home Medical Center 1608, West Court, Pasco, Washington. There's the lawyer's office here around the corner, services and has their service person's lawyer's office at 110. Mortgage services and insurance congestion.
Respond initially to the jurisdiction question, I think the complaint does include specific damages allegations that if you just add them up, it adds to more than $9,000.
Yeah, but only if you have causes of action that are seeking, that are asserting alternate theories. I mean, if you have a claim that says I want $40,000 for breach of contract, and then if you find there's no contract, I want another $40,000 for quantum value and recovery for jurisdictional purposes, you don't add the 40 and the 40 as alternative theories.
I think that's a fair statement.
And here, I don't think you can just simply aggregate causes of action that seek the same damages, but with alternate
damages that can be asserted for each of the causes of action is that of loss. In this circumstance, there can be other damages beyond whatever.
The complaint doesn't cap damages. It says in excess of, which I know is the practice in some jurisdictions. What is there that support the proposition?
There is a specific reference to damages in excess of $50,000 that is specifically tied to the alleged lost property. Then there are the separate references to damages in excess of $10,000 and for the causes of action for contractual breach of implied covenant and the causes of action for tortious breach of implied covenant. Each of those are capable of separate compensatory damages, whether it's in the form of the embarrassment or other loss.
Try to play that card. Do you have any authority that supports the proposition you collect under each category for the same loss? Or that in fact there will be different losses? What would be the different losses?
You can't collect for the same loss in terms of the lost property, but there are, there are other damages that are potentially available. What? There was the discussion there from counsel with regard to embarrassment, other losses that he claims from these other items that were taken from him.
Distress is what you're saying.
Emotional distress, and then there's the punitive damages claim in there.
So he argues in his motion for summary judgment that he's seeking $300,000. Is that amount actually in play? Does he have any basis for a punitive damages claim in this scenario, or do his allegations amount to a punitive damages claim?
The plaintiff was able to state a claim, or rather a prayer for punitive damages. Punitive damages are available in Nevada for certainly the tort of breach of implied covenant.
But under the law that we have to apply and see whether we have jurisdiction or not, I mean, the fact that someone says, I want $300,000 in punitive damages, that doesn't automatically get you over the top for $75,000 if at the time of removal there's no possible basis for that claim under the law of the state where that we have to apply, right?
I think that's true. I don't think there's any finding in this circumstance or basis to make a finding that there is that lack of possibility. Instead, there are the separate causes of action that each permit damages, as well as the ability for plaintiff to pursue punitive damages. Another avenue to look at this that I encourage is looking at the Chavez decision that speaks to a circumstance very similar.
Here that it was something he couldn't have exhausted. How can he put those in the complaint?
Knew that they had accepted it. So why at that point does he get to file the claim?
In numerous cases, circuit courts have held that even when a prisoner is excused from exhausting administrative remedies and continues to use the grievance process, that does not negate the fact that administrative remedies were previously unavailable. So once the prison was delayed in responding to
I was honestly hoping I would get picked, you know. I wanted to actually get to experience what other people have. I've heard some good, some bad, but
I'm one of those people where I have to experience it myself. And it was honestly one of the best experiences I can say I've ever had.
I'm Richard Paez, a judge on the United States Court of Appeals for the Ninth Circuit. And I want to thank all of you for answering the notice you received for federal jury service. While not all of you will be selected, your presence here today makes it possible for the court to select a jury from a representative sample of our community. If it wasn't for people like you, we would not be able to make real the Constitution's guarantee of the right to trial by jury. This right is included in our Bill of Rights and guaranteed by the 6th and 7th Amendments to the United States Constitution. It applies to all criminal trials and many civil cases.
When I got my jury summons in the mail, I sort of rolled my eyes and thought, oh, they're still coming after me. I had been a stay-at-home mom for a number of years with young kids, and I had deferred several times. But my kids are really old enough now, and I realized this was probably a good time for me to serve.
When I first got the jury summons in the mail, I was very nervous. I thought about shredding it and acting like I never got it. Didn't do that, responded to the questionnaire, and got selected.
I can understand how someone who gets a notice to come down to court and see if they're needed to serve as a juror might say or think, gee, I don't want to be bothered. What if they don't pick me? I'll have gone down there for nothing. But I think most of us realize that you might be yourself in court someday. You might need to have issues addressed by a jury drawn from your own community.
When I got my jury summons, I was really excited. It was the first time that I'd ever received a jury summons, and I am actually 36 years old. So I was very excited. I wanted to sign up for it. I wanted to be a part of it. I wanted to learn what everything was about. And I knew that it was my turn to actually do something and be a part of something that was very unique.
When we first got our Constitution and started having jury trials, only white males, men who own property, could serve as jurors. And as recently as the early 1970s, only 6 or 7 years before I became a Supreme Court justice, there were still states in the United States that excused a woman from jury service anytime she did not want to serve. But by including a large spectrum of the community in the jury pool, today we're assured of a broad perspective in the jury box. We want a full sampling of the community because these are the people to whom we entrust our lives, our honor, and our most important issues.
Remain seated. Come to order.
Good morning, ladies and gentlemen. My name is Susan Ilston, and I'm the judge who will be presiding over the trial, which will take place in this courtroom over the next few days. Welcome. First, let me tell you thank you for being here. We couldn't function in our system without the assistance of people like yourself. So first, let me tell you what will happen over the next period of time in this courtroom. First, I will have some questions to ask all of you. After that, then the lawyers will have an opportunity to ask you a few questions too. Before I ask you any questions, though, I want to find out about your availability. And when I'm asking you about that, one thing you should bear in mind is that after you have heard the entire case, then you'll have a chance to go back in the jury room and deliberate. So the first series of questions I want to ask you is whether there are any of you for whom sitting on this case for the length of time that we've estimated would be a genuine hardship. And I don't mean an inconvenience, because it will be inconvenient to all of you. But if there is any of you for whom sitting would be so inconvenient and difficult that you feel you just really wouldn't be able to pay attention to the case and give the parties the fair trial they're entitled to. Anybody who feels that way, please raise your hand and let me know. All right, yes, sir.
I am Mr. Little, and my wife broke her ankle 2 weeks ago, and I'm taking care of her. I have to be around to take her to the bathroom and other things around the house. She cannot put any weight on her ankle, and right now it's very difficult, as we have no other help, and I have to be there. So I don't think I can take take that much time.
Do you have a job, sir, outside the home?
No, I'm retired.
All right, thank you. Yes, ma'am. What's your name?
Ms. Green?
Yes, ma'am, Miss Green.
Your Honor, my husband owns a business and I'm the sole employee. If I were to be out of the office for that length of time, there's no one to replace me.
What kind of a business is it?
He sells computer equipment and I'm the one who handles all the bookkeeping, answering phones, sending out correspondence, really anything having to do with the office.
Thank you. Anybody else? And by the way, today is the day to tell me. Next week would be a really bad time to tell me. Yes, ma'am.
I do not know if it's a real concern, but I have a trip scheduled for 3 weeks next month.
All right, thank you, Ms. Ruiz. All right, anyone else with a scheduling hardship you want to tell me about?
For more than 200 years, our system of justice has depended on the common sense and sound judgment of citizens, with no stake in the cases they are called upon to decide, other than to render a fair and just decision in light of the governing law. As jurors, your decisions will be important, maybe affecting defendants' liberty, or millions of dollars. But whatever the issue, remember that each and every decision matters a great deal to the people involved in the case. What we ask of you is to bring your sound judgment and an open mind into the courtroom, so that you and your fellow jurors will be able to render a fair and impartial verdict should you be chosen.
We understood that our decision had a major impact on the life of this individual, and we really didn't take it lightly. We felt like it was our responsibility to come at it with all of our talents available to us, and so it was definitely an experience that reaffirmed my feelings about how our democracy works.
One of the things that impressed me about the group that I served with was, of course, we came in as complete strangers, but what I was impressed about was how, not knowing anything about the case, the people serving in it, and how open-minded, how impartial they could be.
All right, ladies and gentlemen, at this point, I have a set of questions, and I'm going to require each of you to answer these questions out loud and in front of each other. But do not fear, you will know the answer to the questions. If you have a spouse or a partner, what does that person do? Do you have children? What are your hobbies? Have you been in the military? Have you served on a jury before? Questions like that.
I'm a self-employed carpenter. I'm a member of the Horsemen's Association. My hobbies are golf and horses. I'm single because my wife is deceased and I have a 9-year-old son. I've never been on a jury and never been in the military.
Can you think of any reason, sir, that you can't be a fair and impartial juror in this case?
I'm a legal secretary. I have a son and daughter. I'm divorced and I was a juror twice on
is before the court is whether there was a material change in circumstances.
Right.
And we have to measure point A and point B, as Judge Ferris said. I think we know what point B is, what evidence we have of the country conditions of point B.
Right.
But my point is, while the IJ said, well, there hasn't been any change, since at point A, the religious freedom report was not considered, it seems to me she's got an argument that there's a different delta there. There is a material change of circumstances because the snapshot at the beginning of the period was only the 2014 report, and they're just interested in the government's response to that.
Well, I would say that the evidence she did submit, which predates her hearing, shows that Al-Shabaab was targeting Sufi Muslims throughout Somalia, as were they targeting military, police, NGOs, civilians. This is an indiscriminate terror organization. So whether we're looking at what is point A, I think what the immigration judge was looking at was the entire evidence she submitted. So she lumped it into two groups. There was the evidence that was
available, so everything that had a date before January 2016, she said that's not new evidence as required under the statutory exception to the 90-day deadline. So then she looked at the evidence that was new and compared it, and what she saw was, regardless, it just shows that Al-Shabaab is an indiscriminate terror group, and she didn't abuse her discretion in deciding that. So I don't know if that answers your question.
I think it does, but I'll let it go. I think you maybe have answered it to the extent.
And I apologize.
I don't think you're trying to avoid it. It's fine.
Typically, and what the board has said in matter of SYG is the point of comparison sticks solely with the motion to reopen. So we're not looking at anything underlying the removal order. We're looking at the evidence submitted with the motion to reopen, and she
fully appreciate that. I'm just trying to get the baseline. You're now speaking up to point B. That's what was submitted with the motion to reopen. I'm trying to get the baseline because we're trying to assess whether there was a material change in circumstances.
Right, but the point A also has to be submitted with the motion to reopen.
Yes, it was. It was. But her argument is, maybe, let me get at it this way. Does she, what is your response to her contention that at point A, the immigration court only considered, or didn't consider the religious freedom report? What's your response to that?
My response is that the court lacks jurisdiction to consider that argument, because that's an argument.
Just for purposes of assessing the baseline.
What she's really doing is attacking the immigration judge's failure to consider evidence at the original removal
Whether
proceeding.
she is or not, I'm not. I'm just trying to figure out what the quantum is of changed circumstances. But I'll let this go now.
Okay.
I don't think we're getting anywhere. Thank you.
And I apologize.
Not at all.
Would you address the sua sponte point? Tell me why we shouldn't remand this case to the BIA to explain the basis on which they denied the motion to exercise their discretion under sua sponte to see if there was some legal or constitutional error under Bonilla.
Okay. I reread the motion to reopen 3 times this morning. Not once does her motion to reopen state the word sua sponte. And if you look at the motion to reopen, this is at page 91 through 92. This is where she acknowledges that she's seeking to reopen in the interest of justice. That's how she phrases it. She doesn't cite to the regulation on sua sponte reopening. She doesn't utter the word sua sponte reopening.
So the argument I made is one she didn't.
Right. So the immigration judge was under no duty to consider sua sponte reopening because she phrased it as she was seeking reopening in the interest of justice to further develop the record. And again, the majority of her arguments go to the IJ and the original removal proceeding. So if she doesn't ask the immigration judge to sua sponte reopening, which is a misnomer because it's something that the immigration judge or the board does on its own motion, the immigration judge is under no duty to consider a request for sua sponte reopening.
But it is under duty if a request is made for sua sponte reopening to deny it and explain why.
I would agree that the IJ would be under a duty to address arguments made. They can't just fail or ignore arguments, but it's our position that it wasn't even made in the motion to reopen. And again, I read it 3 times this morning. I would urge the court to look at page 91 and 92 of the record at the motion to reopen to see how it was raised to the IJ.
Thank you, sir.
And if there are no further questions, I'm taking it down.
Ms. Carr, have we missed something on your sua sponte point? Did you ever move the BIA to exercise sua sponte reopening?
In the motion to reopen, I addressed it as a motion to reopen in the interest of justice. In the briefing to the Board of Immigration Appeals, I did specifically cite to the statute and mention the term sua sponte reopening.
So it was a citation to a statute which mentions sua sponte reopening.
I did make that specific request to the board.
All right, thank you.
What is the baseline? I'm going to try again. On my baseline question, and what I want to know in particular is what is your contention? You think that in 2014 that the religious freedom report was not considered? How do we know it was not considered?
If it was considered, the judge certainly did not mention that in her
denial of the motion to reopen.
What's the appropriate baseline for purpose of determining, comparing point A to point B? What should we look at point A?
I would say the baseline would have to be the evidence that was before the immigration court at the time of the merits hearing. In this case, the only objective evidence that was in front of the court was a 2014 country report and nothing else.
Thank you very much.
Thank you.
Thank you both.
The case of Abdi versus Barr will be submitted, and the court thanks counsel for their argument. And we'll go to the next case, which is USA versus Edward Stamper.
My name is Wendy Holton and I represent Mr. Stamper. The only issue in this case was whether Mr. Stamper knew that Kay was physically incapable of declining consent. But that's not how the jury was instructed. The jury was instructed only that he had to know that he was having sex with her and that she was incapable of declining consent. In fact, in this case, the jury was specifically told that the government was not required to prove that he knew his acts or omissions were unlawful. In essence, under the facts of this case, the jury was instructed, a verdict was directed against him. To request the appropriate jury instruction in this case, Stamper's trial counsel did not have to anticipate a change of law, nor did the Eighth Circuit cases of Brugiere and Rouillard add an element to the offense of sexual assault. Had his counsel heeded the admonition contained at the beginning of the pattern jury instructions of this court, he would have seen the admonition that they are not mandatory and must be reviewed carefully before use in a particular case.
So if he had requested a modification of the instruction, what authority would he have cited at that time?
He could have cited actually a plethora of United States Supreme Court precedent. He could have gone to the rule, in particular, a case where the statute at issue was very, very similar to the structure of the statute in Stamper's case, in excitement video. That statute is set out at page 4 of my reply brief. That the structure of that statute is almost exactly the same as the structure in Stamper's case. And there, the court held, relying on even older than 1994 cases, Morissette, reinforced by Staples, instructs that the presumption in favor of a scienter requirement should apply to each of the statutory elements that criminalize otherwise innocent conduct.
So the Supreme Court said that in Staples in 1994, right? And then in Flores-Figueroa, it cited, which is 2009, I think it's also before your case, cited excitement video. Courts ordinarily read a phrase in a criminal statute that introduces the elements of the crime with the word knowingly as applying to each element. Right? Yes. Okay, so he could have cited these authorities from the United States Supreme Court and said, we need this element read in to our jury instruction, but he didn't do that.
That's correct.
Since this time, our court has come down with additional case law that says that that's not an element, right?
No, Your Honor.
Well, we have in a statute that's almost identical.
But that in the case that I believe that you're referring to, Juan Pablo Price, in that case, there is a footnote that specifically says we're not saying that Brugiere isn't controlling here. We're just saying that the penalty isn't such that it can't essentially be that the rules of excitement video and Flores-Figueroa apply. But
I'm going to disagree with you about that, but I'm not, or if I do, I'm not sure it matters today. Here's my problem. We have, are you aware that we have potential en banc activity pending on this issue?
I am not.
Okay, just take that as a hypothetical. If we have pending en banc activity on this issue in this case, does that mean we should hold this case, or what should we do? If we're grappling with the question, for both of you, if we're grappling with the question about whether or not the defendant's awareness of her incapacity should be an element, is that going to be outcome determinative here?
Yes. I mean, if the knowingly element applies to her inability to consent, or not to consent actually is an issue, her inability to decline participation.